There we go. Okay, so when we open our forms, again, I'll click all forms. I have the California Association of Realtors library as the default. That's where all of our purchase agreement, listing agreements, all that stuff is housed for us. But if I click the drop down, there are other libraries. Now, not all of you are going to have all of these libraries because most of you are not members of the Downey Association or the San Diego Association or the Orange County Association. But what you will have is this right here. On mine, it's the fourth one down. Yours probably is the fourth one down too. C.A.R. sample letters. And it's going to shift to a different database of letters that we have access to. And there's probably 30 or so in here. And I've picked out, like I said, a handful that I thought we would review today. So let's take a look and see what we got in here. Okay, the first one that we have is, and this is just in no particular order, that's alphabetical based on when I added them to my zip form. So the first one is this: access to premises letter. Now, most of these, all of them are going to have a cover letter, okay? And most of them are going to say what the purpose is, okay? Now, the reason why I chose this one is because it's for tenants, and we don't normally do property management, but we do show tenant occupied property. And it says here the purpose: for use when a tenant is refusing entry to agents who wish to show the property to prospective buyers or tenants, or have work performed, i.e. Meeting a handyman, okay? So read the cover letter and then look at how it should be delivered. Not all of them are going to have the purpose, but most of them do. And when I scroll down, here is the letter. It says date to, who is it to? That's going to be the tenant. Then we have the address, and then it's going to state here what happened. So, on this date, we gave you a notice of entry form, and we followed up with a notice of sale and entry form, and we wanted to show the property to prospective purchasers. We would check that box, okay, for instance. And then it's going to say, well, you've refused, and you now may be violating California law and your lease agreement. Now, you have to make sure for this one in particular that the lease agreement does allow for entry for things like having work done on the property or what have you, which mostly they do. And California law does state that we can give a 24-hour notice of entry to show to a prospective purchaser. And then it goes on to say that here's the civil code that says we can come in. And if we check this box, you have to make sure, but the rental agreement also says you have to let us in. And then it says later on, basically, if you don't allow us, we may have the right to evict you. So breaching the contract, breaching the terms of the lease allows for the beginning of an eviction. And if we have someone that's refusing to allow entry, but the lease says they have to allow entry, then they would have breached the lease, okay? Be aware that an unlawful detainer will be on your public record. And we're hereby giving you this notice that if you don't let us in and we have to go through this process to get you out and evict, well then, you're notified that you'll have a negative credit report. You may have a judgment against your credit, et cetera, et cetera. Okay, so it's just a letter that says, it's kind of like a CYA or a cover your assets, right? It's basically saying, I've asked you to do this. You chose not to. I urge you to reconsider. That's the basis for any letter that I would ever write when I'm asking somebody to do something and they've chosen not to. It says, I've asked you to do this. You chose not to. I urge you to reconsider. And that's basically what this notice is. So that's the first one that we'll look at. Tenant refusing to allow access to a property. Let's look at the next one that I got. And I'm going to buzz through this pretty quick, like I said, because the intent here is not to show you exactly what each of these forms is or how to use them. It's more to tell you that they exist and that you need to use the proper forms for any situation. I had a call earlier today. I get them all the time about contingency to sell or contingency to buy. What should I write in the counter? No, you got to use the right form. Always, always. Remember, in the back of your mind, just think to yourself, Nick said there's probably a form for this. I'm either going to go find it or I'm going to give them a call to figure out what it is. You guys should all have my number. Always welcome to call. Okay, here's the next one. The next one is they're all great, okay? The next one is this: acting against broker advice, buyer. So if I go back up to our purpose, it says here, this letter can be used anytime that the broker, which is me and you guys as the agents, the brokerage, Keller Williams Pacific Estates, Long Beach, Cerritos, and La Mirada representing here. can be used anytime the broker considers the client's actions to be sufficiently risky that the broker believes it appropriate to warn the client, okay, in writing against their course of action. For instance, we have a transaction. Buyer is refusing to close on time without a holdback of money that hasn't been agreed to, et cetera, et cetera. But there's been a notice, there's been a demand to close. The buyer already released half of their deposit to the seller and will have no way to recover it. And they're refusing. And I had our agent put this together and said, you need to advise them that they're acting against their advice and that they need to potentially consider either talking to an attorney or following our advice. Otherwise, they have risk. And that's what it says here. Dear buyer, real estate is complicated. It's come to our attention that you are intending to take the following actions. And there are some check boxes that are pre-written, or you can type in whatever you want. Here's some things where we don't advise clients to, what things we don't always advise our clients to do. The first one says to make a completely or partially non-contingent offer. Okay, that's something that we don't advise. Or remove a contingency before the contract requires it or before receiving all the information needed. Or the next one is to fail to make property investigations, like not doing a physical inspection, not asking for a termite report, not having a plumber go out. The next one says you're acting against our advice if you close escrow without receiving reports and disclosures, any or all. Here's another great one. Many of you have clients that are buyers trying to buy in a tough market, and you're having to write multiple offers on different properties at the same time. Well, we don't advise that your client does that, because if they do, they may be obligated to buy any property that comes back with an acceptance. So it says here, make multiple offers on more than one property, even though you intend to only buy one. Okay. Or make an offer with an escalation clause that could leave them vulnerable, or other. Okay. Or other. And then it says there's risk. If you do what you propose that you're doing, you may be acting against the broker's advice. Okay. So a great kind of catch-all form if your client's doing something that you're advising them not to do and it could harm them, or that it creates a risk scenario for your client. Okay. Next, buyer's demand for deposit when seller cancels. Boy, are we seeing a lot of this right now. Deals are canceling. Both parties disagree on who should get the funds. So depending on who is supposed to get it, you may use this letter or you may use a different one. So what do we have here? No purpose, you'll notice on this one, but I'll tell you what it's for. This is when we're writing a letter to the seller, right? And we're demanding of the seller to release the deposit back to us, okay? So again, it's buyer's demand for deposit when seller cancels pursuant to a notice to perform. So this would be a scenario where the seller gives the buyer a notice to perform. The buyer does not remove the contingency that's noted, and then the seller sends cancellation. And instead of giving the deposit back to the buyer, they try to keep the deposit. Well, you can't do that because the contingency is not removed. So it says, seller, you gave us a notice to perform, and then you cancel the agreement, pursuant to the terms. Under the terms of the contract, it says here, you do not have the right to retain the buyer's deposit. Paragraph 14D says that. Instead, it requires the seller to give a deposit back. Here, we are hereby demanding you immediately sign the cancellation attached, or the escrow instruction that is a cancellation and release of deposit. If you don't do that by X amount of days, we intend to pursue you for any and all legal remedies against you without further notice. And many of you know this, but many of you don't. The contract provides $1,000 civil penalty against a party who tries to keep a deposit in bad faith and refusing to release. Okay. So we're just telling them that they're exposing themselves to liability, potentially legally, and that we might include $1,000 civil penalty on top of that. Usually when I tell a client that's refusing to release a deposit that they may be liable for an extra $1,000, not just having to give the deposit back, that usually gets them to take action pretty quick. So again, this is where a buyer can demand the seller to release their deposit if the seller gave a notice to perform and subsequently canceled the transaction. All right. Another one of my favorites here, confirmation of conversation. I just used this on Friday. What is the purpose? This letter can be used anytime the broker or agent seeks to document in writing the substance of an earlier conversation with another agent, another broker, a buyer, or a seller. Okay. There are some pre-printed options on here, but really you can document anything. And I love this because, first of all, you should all be documenting your file. I think a great standard of practice is go into your phone or on your computer and use maybe like the Notes app and just create a new note for all your transactions. And anytime you have a conversation with somebody about something significant in the transaction, anything related to negotiating or the transaction itself, you want to make a document of the file for you just to keep a running record. But here is where you might send it to the other party to make sure that everybody was clear on what we just spoke about. So let's take a look here. So dear blank, and that would be the buyer, the seller, the agent, whoever you spoke with. I spoke with you at this time and date. At that time, I suggested to you, told you, or informed you of the following. And here's where we'll document whatever you said. Okay. So again, this goes back to the one I did the other day was acting against broker advice. I was speaking to a buyer, advising them, telling them what I thought they should do. They told me that they wouldn't do what I thought they should do. And so ultimately what I did is I then sent this form as a follow-up to say, here's what we spoke about. I advised you to do X, Y, and Z. You told me you didn't want to do that for this reason. Instead, you asked me to do this, right? So I documented all those things and I just sent it over to them. And it's just an acknowledgement. And I always put in there, please advise if I misinterpreted our conversation. And I asked for that to be in writing because you never want to have the he said, she said stuff where you're going back and saying, you said this and you said that. And it was all verbal conversations. You have no proof, you have no documentation. So here's how you will, right? Document your file for whatever it is that you want to fill in, or a couple of these pre-printed items here as well. Okay. All right, let's keep going. Okay, next, demand seller perform before close with reservation letter. So what the heck is this? Well, let's take a look. This is to be used by a buyer when nearing the close of escrow, and it's apparent that the seller has not complied with his or her contractual obligations. So maybe you have a seller who is refusing to fix the property up and do the repairs. Or maybe they're not maintaining the property in the same condition it was in when we agreed to buy it. Or maybe they're not going to include certain fixtures or return personal property that was agreed upon in the contract and you've been made aware of it. Or maybe they're not going to have the property be delivered vacant because of a tenant or for themselves to be vacant as the owners. Or maybe they're not going to pay money or deliver money to escrow that's owed or outstanding, right? So there's all kinds of things that the seller may not do prior to close. And this is basically a form the buyer can send, hey, you haven't done what you said you were going to do. And if you don't, we may be entitled to cancel this agreement, or we may be entitled to sue you for damages, seller. We are reserving all of our rights to perform under the agreement. We're going to close escrow or not. And if we do incur any sort of financial or other ramifications from whatever these actions are, we are reserving our rights to pursue you in a court of law or other for any sort of legal remedies that we may want. Okay. So again, this is when the seller has not performed, but we're still going to try to move forward and close and seek the ability to pursue legal remedies at a later time or cancel the agreement from lack of performance by the seller. Okay. Okay, let's keep moving here. Let's see. Demand seller to close. There's a whole bunch of demands in a row here, so hopefully I don't do the same one twice, but demand seller to close letter. So this form, again, we look at our purpose. This is for a buyer's agent where a seller is refusing to close escrow in breach of contract. Earlier today, I had an agent call me and told me that the seller said they no longer want to sell their property, but we're in escrow. We're in escrow, okay? Now there's two forms that are similar. This one you would use when you are basically ready to close, okay? Demand seller to close. There is a form that we use in the zip forms library called demand to close escrow. This is a letter that says, hey, we gave you a demand to close. We as the buyer have performed all of our obligations, and now you are failing to close and in breach of contract. And we may bring legal action against you to enforce our rights per the contract. These remedies may include things like a lawsuit for what's called specific performance, forcing the sale of the property. If we have to do that, seller, we may also file a lis pendens against the property, which means you won't be able to sell because there's pending litigation on the property and there will be some sort of a judgment. Okay. We also may pursue damages for your breach, including compensatory and consequential damages, because our damages may not just be financial, they may be emotional or other distress related. Okay. And so on. So basically, this is where we're at close and the seller's refusing to close. Now we're putting them on notice and saying, hey, we may be damaged here. And if we are, we're reserving the right to remedy the situation. And it finishes by saying, we want to purchase the property and resolve the situation. Please have your agent contact us. Okay. Now, please have your agent contact us. I want to remind you, these are letters that basically the buyer or the seller are delivering to each other directly, and we're facilitating the delivery. Okay, so it's not a contract per se, it's an actual demand from a buyer that we're passing on to them, which is why basically the buyer is the one that's providing it, and we don't even sign these, right? The buyer signs it, we're getting a copy of it, okay, and that's it. We're not putting our names on any of these things. Okay, in fact, if you'll notice here, okay, it does have our information on here at the bottom as just a sample. So you'll notice on the C.A.R. forms, our information is on a big box at the bottom, but this one clearly says that it's a sample provided to the client. Okay, and each of the forms are preferenced by saying, hey, we're giving you as a courtesy, okay, but we can't advise you on legal matters. So if a seller's refusing to close or buyer's not, releasing their deposit after they removed all their contingencies and canceled, whatever, those all become legal situations, and we are not lawyers. We can't advise on certain situations, but we can facilitate and help you by providing some of these letters that attorneys have drafted for your use. And so here's one that you can use. Would you like me to send that for you? That's basically how you're going to use this stuff. Okay, let's keep going. So we looked at demand seller to close. Here is demand seller to perform. Okay. So Rosie says, do we have to let the selling agent know that we are delivering the letter to our client? You're still going to deliver it to the other agent in most cases. You're still going to basically be the conduit between the buyer and the seller and give it to their agent and say, my buyer sent this letter. Please give this to your client, your seller. Okay. So, and if you don't feel that those letters are being delivered, then you can have your client mail it directly to them and just completely stay out of it. Because again, all these are created to be delivered between the buyer and the seller directly. At least most of them are. Okay, so good question. Thank you for that. All right, demand seller to perform. The last one was demand seller to close. This is demand seller to perform. And this is basically where a buyer, when the seller's attempting to cancel or obstruct the transaction, but it's too early for a demand to close. And so what is a situation where that might occur? Well, maybe they're not giving you access to the property to conduct investigations, right? Maybe they're not letting the appraiser into the property. Maybe they're not providing all the disclosures or reports that they're responsible for. Maybe they're not signing escrow instructions. Maybe they're not clearing the liens on a property or any other obligations. So these are all the, potentially contractual obligations a seller may have. And now the buyer is saying, hey, you're not allowing us to proceed. And with that being said, we may be damaged by you not allowing us to proceed. And so our remedies are to file a suit for specific performance, file a list pendants against the property and have that recorded, and then resolve the issue in a court of law at a later time. Okay, so again, it's just very, very similar. The difference is being it's too early to give a demand to close. You're still in the middle of an escrow. Okay. Again, if you guys have questions, unmute yourself, drop it in the chat, raise your hand. Any of those will work. All right. And I'm buzzing through because we're not even halfway done, but we're getting close to halfway through our class here. So let's look at the next one. Demand for compensation after close of escrow. Here's another really great one. This is when the buyer is going to send a letter to the seller after close because the seller failed to comply with certain terms of the contract or maybe didn't disclose, right? This happens all the time. Buyer moves in, and after the seller moved all their stuff out, there's damage to the property, or they didn't remove a bunch of personal property and the buyer had to hire a junk hauler to get rid of stuff or whatever. So it says, hey, dear seller, our contract said that you're supposed to do one of these things, or there's blank lines for other, but one of these things might be remove personal property, maintain the property in the same condition as of the date of acceptance, or complete certain repairs, or certain fixtures or personal property to stay with the property and you took them, maybe some blinds, maybe a ring doorbell, whatever that might be. Or you're supposed to disclose facts that affect the value of the property, or you're supposed to deliver the property vacant and it's not vacant, or other. Now, on this one, the buyer can put in the total damages that they've incurred, and now this becomes a formal request from the buyer to the seller to pay them or remedy the situation. And if not, it tells them what the next steps might be, which could be hire a lawyer, go to mediation, go to arbitration, or file a lawsuit. So this is a great one for your buyers after they've taken possession and the seller didn't do something they were supposed to do during the escrow. That was demand for compensation after close. Let's look at this. Demand for deposit, buyer failure to close letter. So no purpose written on this one. They don't all have it. But it basically says, buyer, we demand you sign the cancellation and release to the seller the deposit. Okay. This is where your buyer may have removed all of their contingencies and then tried to cancel after the fact with no cancellation right. Okay. So it says here, you have no contingencies, or maybe you have a cancellation, but you don't just have any right to cancel. Some agents have recently said to me, I thought the buyer can cancel for any reason if their inspection contingency is still in place. It's not the case. They have to cancel in good faith based on a reason given in a contingency. That's what this second paragraph says. And then it says to the buyer, we deem your non-performance to be a breach of the contract, and that gives us the right to cancel, but also recover your deposit as damages, liquidated damages. Okay. If you don't give me the money before blank date, we are going to pursue any legal remedies we have available to us, including that $1,000 civil penalty that could be incurred for refusing to sign cancellation in good faith. Okay. So again, this is for the seller to demand the deposit in escrow based on buyer canceling with no cancellation right. Okay.
Uh,
Go for it.
Hello, the one
Hi.
that we just, hey, the one that we just did.
Yep.
Okay, so if they have not removed the contingency, all contingencies, would that also stands?
So let's take a look at it again. It says here, if the buyer there's options here. Either you don't have an applicable contingency giving you the right to perform. Okay, so this would be an example of a couple things. One, let's say the buyer's removed all their contingencies and they say, we're canceling. Well, this letter would say you don't have the right to cancel. Now, what if the buyer does have some of their contingencies? Maybe they have their loan contingency, but they remove their appraisal and their inspection. And then they tell you, well, we don't want to buy anymore because we don't like the condition anymore. We don't want to buy a fixer anymore. Well, if they've already moved their inspection contingency, they don't have the right to cancel anymore. That's not good enough. Okay. So does that answer your question, Rosie?
Yes, yes.
Okay. Very good. Very good. Yeah. And just remember too, like I said, just because a buyer has contingencies doesn't give them the right to cancel for any reason. It's got to be specific to a contingency still in place in a transaction. All right. Let's see. Here's another good one. Demand for deposit for contingency cancellation. So again, this one is going to be to the seller, and it's basically saying this is where it's similar to one we looked at previously. This is where a buyer has all their contingencies in place or the applicable contingency in place, and it's giving them the right to get their money back, but the seller, for whatever reason, is refusing. So this is a demand from the seller saying, hey, give me the money back. I'm the buyer because I have my contingency still in place. Okay. So here's where I think people get this notion that a buyer can cancel for any reason as long as their inspection contingency is in place. This checkbox right here says the inspection contingency, which hasn't been removed, is especially broad, is stated as follows: acceptance of the condition of and any other matter affecting the property. Um, and then it says the contract thereafter specifies a long list of inspection rights, and the law gives wide latitude to exercise this kind of contingency based upon my own good faith. So here's where basically it's like, if I have an inspection contingency, I can pretty much cancel for any reason related to the property itself, including its physical condition, including surrounding neighborhoods and street noise and any other thing that could affect the client living in the property. So that's where it says it's a pretty broad right to cancel. Now, if you sign a deal that has no loan, no appraisal contingency, and only an inspection contingency, and the buyer tries to get a loan and gets denied, that's not a right to cancel, in my opinion, based on the inspection contingency, because it doesn't relate to investigating the property. It relates to getting financing, which in this case, they had removed that contingency. So hopefully that makes sense. Let's keep going. Okay, I think that was the last of our, I thought it was the last of our demands. Nope, we got a few more. So here's the next one. Demand for full commission. Hopefully you guys won't have to go through this very often, but we have had this happen a couple times recently where another broker is refusing to pay the compensation that was agreed upon in the MLS. Okay. So here is where we're making a demand of the listing agent stating, I represent the buyer. We had a compensation in the MLS that was noted as blank, but you are only willing to pay me whatever. Maybe it was 2.5, but now you're saying I'm only going to do a 2% commission. Okay. It says if you change the MLS after our offer was presented or you were notified, that has no effect on the contingency rights. Okay. I'm sorry, the compensation rights. So, what is in the MLS is what the offer of compensation is. If the seller attempts to modify the compensation through a counteroffer, that also has no effect on my rights for a couple of reasons. One, my agreement for compensation is with the listing agent through the MLS, not the seller. And second, even if the buyer agrees to the counteroffer, the buyer doesn't have the authority to act. So what we're kind of talking about here, ladies and gentlemen, and you guys, I'm sure have seen this from time to time, compensation being negotiated in the contract, purchase agreement, counteroffer, seller counteroffer, buyer counteroffer. You are not allowed to negotiate commissions on a purchase agreement or counteroffer. it has to be done using the appropriate form, which is the CBC, Cooperating Broker Compensation. So if you receive a counter and it says your commission's being reduced, it's not a valid agreement because the commission agreement is between the listing broker and the selling slash buying broker through the MLS. That's one of the big functions of our MLS system, is to establish the ability to cooperate between a listing and a buying brokerage for commission. You know, when you guys take listing agreements, it says how much commission you're charging, 5, 6%, whatever you guys charge. And then further down, it says, here's how much we're going to offer to the outside brokers to cooperate so we can have cooperation, which not all markets have that, but we do, right? So if you're going to negotiate that commission, that's fine. That's you can do that. It just needs to be done not in the contract between the buyer and the seller. It has to be broker to broker. Okay. So the last paragraph here says, if you do try to negotiate my commission on an offer or a counter offer, I am demanding payment of the full amount of compensation as promised in the MLS. I have no intention of interfering with escrow between the buyer and seller. However, if we're not paid in full, then we hereby reserve our rights to recover unpaid balance in full at a later time. So I've had this happen twice recently. Number one, a seller who was also the broker selling their own property said that we would have damages. I think one of the agents who had that was on the phone, right, or is on our Zoom call today. So you know who I'm talking to. And we had to take them to arbitration, and ultimately the arbitration won. Now we got to pursue that payment, which may or may not be easy. That's not an automatic guarantee, but it is something that did occur where the arbitrator said, yes, you should have gotten full payment. And then just about a week ago, I had a listing agent send our agent an extension of time addendum that said, we're going to give you more time, but you have to pay $100 per diem. And it said the buyer's agent commission to be reduced to 3% or 2%, listing agent's commission raised to 3%. So clearly the seller probably didn't even know about this because the agent was trying to increase their own commission, not even credit it back to the seller. So I had to call their broker. Broker stepped in and told that agent they cannot do that. And we closed the deal and we got the full compensation. So these are some of the forms that will help in different scenarios if another agent's trying to negotiate your commission using the purchase agreement or counter offer. All right. That's our demand for full commission. Let's see. Here's another great one. Demand that offer be presented to seller.
I like that.
Oh yeah. So I'm getting this all the time. You know, I don't think the other agent's presenting my offer. I think they're trying to double end the deal, blah, blah, blah. There's actually a few different forms. This is one of them. This is probably the last option we would use, but there are others. And so if we look here, it says this letter is to be used when a real estate agent representing a buyer has submitted an offer to purchase a property, but has not received any response indicating that the seller has been presented with the offer. And
1 second. It's right between my.
as a reminder, thank you, Brooke. As a reminder, it is a violation of the Code of Ethics to not present an offer or to respond whether an offer has been presented unless a seller has given written instructions to that agent to not present offers either until a certain time or some other circumstance. So this form basically says, I represent the buyer. I submitted an offer on this date. I submitted it to you via whatever method, email, fax. We still got a fax number out there, or personal delivery. I have knowledge you received it because you confirmed my email, or you opened the email, or you texted me and said you got it. After I submitted that offer, I tried to reach you on all these dates and times via phone, email, or other communication. Your failure to present the buyer's offer, which I believe to be true, may have serious consequences. You may be in violation of the law. You may be in violation of DRE licensing rules. You may be in violation of MLS rules. You may be in violation of the NAR Code of Ethics. And a failure to present the buyer's offer to the seller may give rise to a lawsuit brought against you and your broker by the seller or the buyer for legal claims. Also, as a member of the MLS, which the vast majority of the time, you guys are all members of C.A.R. MLS. You're probably doing deals in C.A.R. MLS. You're obligated to make arrangement to present the offer as soon as possible, or tell the broker a satisfactory reason for not doing so under a certain rule adopted by the MLS. Number 7, I hereby demand you immediately present the offer. And then furthermore, okay, depending on if this applies, which it should, upon written request by a cooperating broker, a listing broker must affirm in writing that the offer was presented or the seller has waived the right to have the offer presented. Okay, that does apply because our NAR rules do state that we can ask for confirmation an offer was presented. If we do not receive a response to the offer within a business day, we may have no choice but to pursue any and all legal remedies against you without further notice. And again, this is just putting them on notice that we can take actions for your refusal to present. And in the hot sellers market like we're in, we see more and more of this. Agents not responding, trying to double end, et cetera, et cetera. I just had an issue over the weekend where the listing agent texted our agent and said something to the effect of, I'm pre-approving 2 of my own buyers and they look promising, when we had already submitted an offer. Well, that's in writing now. That doesn't look very good for that agent, by the way. So no bueno. There is a checkbox here at number 10, intent to contact seller directly. It says, if I can't contact you despite efforts to do so within a day, and you do not contact me, then I reserve the right to contact the seller directly to negotiate a purchase of property for my buyer. So what this basically says is, agents ask all the time, can I take my offer to the house of the buyer and let them know, or the seller, and let them know that we wrote an offer on their property? In some circumstances, the answer is yes. If they're not responding to you or getting you the confirmation of whether their offer was presented, you can do that. Okay. Thank you for your cooperation, blah, blah, blah. Okay, so that's the letter we can send if we believe the offer has not been presented. There's another one we'll look at in just a second that is similar to this, okay? But, let's keep going. Another great one, very applicable right now. Demand that seller vacate. Basically, what we've got here is a notice or a letter that says, hey, seller, we had a seller in possession or a residential lease after sale for a couple of days or a couple of weeks, and you have not moved out. Well, since you haven't moved out, the buyer can now initiate proceedings to pursue you for monetary damages because of your breach of contract. You have breached the contract for not vacating the property. Okay. They may initiate legal proceedings to have you lawfully removed from the property through an unlawful detainer. Your actions have legal, practical, and emotional ramifications. You entered into a contract. You have not resolved that contract. We're happy to work with you to complete some sort of resolution now. Please contact me immediately before we decide to move on to legal remedies. Okay. So another great letter when the seller doesn't move out, which we're seeing more and more of for various reasons during our pandemic. Okay. I think that's the last of our demands here. Let's move on. We got 6 more. Receipt of subsequent offer letter. This is an interesting one. This is basically, let's look at the purpose. This letter is to be given to the seller by the listing agent, and the use is when a purchase agreement with a previous buyer has been canceled, but the escrow is still open, meaning escrow cancellation has not been signed, and the seller has received another offer. So basically, we're giving a letter from us as the broker, and we're saying, hey, I know you canceled your escrow. It looks like you had the right to cancel your escrow, but the buyer hasn't signed the cancellation instructions. And we just got an offer on your property. So what do we do? Well, our duty as the listing agent is to either recommend you accept the offer, the second offer, subject to cancellation, or you seek legal counsel. So all we're saying is you got to be careful if you just accept another offer and move forward. It even addresses the fact that, opening with another escrow company You still need to tell the second buyer that you've opened with a second escrow, but you have a first one open that hasn't been canceled yet. So I think you can accept the offer. I think you can accept it subject to cancellation of the existing escrow. And if you choose to do otherwise, then we recommend you talk to a lawyer about what that could mean for you. Okay. And if you notice here, almost all these letters end with, we advise you to talk to a lawyer, or you should seek legal counsel, or you have legal remedies available to you. So, we're not lawyers, guys and gals. So we can only advise to a certain extent. And then we have to move it to the professionals that handle contractual disputes, and that is our attorneys. Okay. All right. Let's keep going here. So, receipt for written confirmation of a presented offer. So here's where we go back to, giving proof that an offer was presented. So this one is for when a real estate agent representing a buyer has submitted an offer, not received confirmation that it's been presented. Okay, so this is probably where you would start when you've submitted an offer and you're not getting any sort of response with it. Okay, so it says here, I represent the buyer. We made an offer on this date. It was emailed to this email address, and we have not received confirmation the offer was presented. The NAR Code of Ethics state that upon written request, a listing broker must affirm in writing that the offer has been presented or the seller has waived the right to have the offer presented. Consider this a formal request for written confirmation. So what's the difference between these two? The first one we looked at is a demand that the offer be presented. This one is a demand for confirmation of the presentation being given back to us in writing. Okay. So on this one, what we're asking for is that we either want a copy of the offer with the seller's acceptance on it, right? We want the offer accepted, obviously, or we want the seller to initial the rejection box, or we want you as the agent to initial the presentation of offer box. So keep in mind, the NAR Code of Ethics says the listing agent has a duty to present all offers, and if they're asked, they have a duty to inform the selling agent, the buyer's agent, in writing that their offer was presented. So this isn't necessarily asking for the offer to be presented. It's asking for the proof of presentation to be delivered. So it's a little nuanced, but it's slightly different. Okay. So generally speaking, I would ask for this to be done first. If you have a buyer, you're not getting an offer responded to, and then proceed to the second one that we looked at a little bit earlier. Okay. All right. We're moving and grooving. Next, risk of failure to close. Okay. What is this? This letter is for the listing agent to give to a seller, and the situation is where a seller is refusing to transfer the property in breach of contract. So the seller is saying they won't do something in terms of delivering the property or closing the escrow. And it notes here, again, this is from the listing agent to the seller. So if it's our listing, we're saying, hey, you entered into a listing agreement and you may be in breach. Therefore, the buyer may have the right to sue you for damages. And not only could you be liable for damages to the buyer, but if you're in breach, that could also trigger a commission right to my brokerage, the listing brokerage, for interfering with the ability for us to sell your property because you're not taking the actions that you hired us to facilitate for you, right? They're getting in the way of the listing agreement. And we may have the right to seek our commission. The buyer also could potentially seek their commission directly from you as well. Okay. You may have certain opportunities to cancel a deal, and maybe you're not exercising one in good faith. I urge you to take this seriously and consult with your lawyer to determine your rights. Okay. So again, this is where the seller is preventing us from doing our duties to sell the property, and there's a risk of not closing, failure to close, breach of contract. Okay. Okay. Seller failure to deliver documents. What do we got here? Well, this is where The buyer's agent may send this to the buyer if the seller hasn't given required documents. This is where the buyer's agent is going to tell the buyer, hey, you haven't been given everything you're supposed to receive. The seller is required to provide you with contractual and legally required disclosures within 7 days, and they haven't done that as of yet, or we're missing certain disclosures. Maybe not all of them, but some of them. I gave and it goes on to state, I've delivered to the listing agent a notice to perform for the seller to give us these documents saying they have not delivered them yet. The stuff that's in those disclosures are very important and could impact maybe your assessment of the value and desirability of the property. It could affect your decision as to whether you would proceed with requesting any sort of repairs. It could potentially have disclosures that could affect your ability to purchase the property and ultimately their decision to continue with the transaction. So we're saying, look, the seller hasn't given us all the paperwork they're responsible for, and there could be stuff in there that may affect your desire to buy this property. Okay, so it's your decision on how you want to proceed. And I recommend you talk to an attorney about what the ramifications of the seller not delivering these, even though we have made requests to provide. Please call me to discuss, et cetera, et cetera. Okay, and that's it. So that's where our buyer's agents will send this letter to a buyer when the seller's not providing documents. Here's another one for failure to provide disclosure letter. Now this one's slightly different in that this is when the buyer's agent will send to the listing agent when the seller hasn't given specific disclosures. So the first one was telling our buyer as a buyer's agent what the ramifications of not receiving proper disclosures are. Here, where the buyer's agent is telling the listing agent that, hey, we gave you a notice to perform to provide all of the disclosures required by law. I haven't received X, Y, and Z. And if the seller doesn't provide them, I have to advise my client that they need to seek legal counsel to discuss options, which may include canceling, or it may include forcing the sale. Please, your prompt attention to this matter is greatly appreciated. Okay. So one is buyer's agent to your own buyer. One is buyer's agent to listing agent when a seller is not producing the required documents. Okay. And then lastly, written confirmation of presented offer. So this is the third one in the buyer's agent trying to get confirmation their offer was presented. Purpose, this is to be used by a listing agent in response to a request from the buyer's agent to confirm offer presentation. So buyer submits an offer through their agent. They don't hear a response. The buyer's agent then asks the listing agent, we need proof that our offer was presented. Don't hear anything back. We would send one of the previous letters we've already seen that says, we're demanding you present our offer. We're demanding written confirmation our offer was presented. This form here allows the listing agent to confirm we've received the offer and either the seller has waived their obligation to have it presented or there's a letter from the seller that says they don't want offers presented until a certain time or whatever. The seller can instruct their listing agents to say, don't give me any offers until blank date. Don't show me any offers under this price. Don't show me any offers that don't meet the following criteria. So only in that instance can a listing agent not present their offer to their sellers. But that's very, 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 very rare to have a seller give that written instruction to their listing agent. So this form is where the listing agent can confirm your offer was presented, and then the listing agent would then sign at the bottom here. Okay, so mostly we would use this first checkbox. So if you have a listing and you're getting blown up by buyer's agents demanding proof the offer was presented, you can either use this form or you can initial page 10 of the offer where it says proof of presentation. All right, ladies and gentlemen, wow. I mean, we just went through like 20 different forms there. So, and it was a lot. Any questions, comments, concerns based on any of the stuff that I can answer for you right now? or anything at all. Any other contractual or real estate related questions? I can't see most of you, so my assumption is I put you to sleep, and my apologies if that's the case. Otherwise, I think we're going to be done, guys and gals. Does anyone